Yes, Mr. Boston, you are raising a point.
Sometime before the 2nd of March, Your Honor, sometime before the 2nd of March, the President of the Cooperative Republic of Guyana has issued a proclamation naming a date for election. That was the 2nd of March 2020. Election, in its wider sense, connotes the time when the proclamation was issued and right down to the date when the final results are declared. So polling took place on the 2nd of March. The counts for each district were tabulated and declared except for Region 4. The counts, Region 4, there were 879 polling stations. About 350 of those polling stations were examined and the statement of polls were tabulated, and if I use the word verified, if I use the word loosely.
But I don't know what that means.
Well, they have been checked. 350 statement of polls on 350 polling stations has been checked.
Or just let me ask you this question. The applicant's affidavit refers to, just let me get this.
In the supplemental affidavit, my learned friend has just said it has gone from 350 to 421.
But so that's what I was going to ask you.
Yes.
Are you giving evidence in the bar table?
No, from the affidavit.
So
421.
Well, so then are you accepting their affidavits? You see, because you have no, the respondents have not requested to file any affidavits in answer. You said you're raising a preliminary point.
Yes, well, sorry.
But you are making statements of fact from the bar table. You just said 350 of those polling stations, I guess it's statements of poll, you mean, were examined. And then you say you are relying on a supplementary affidavit filed by the applicant that says it's now 400 and something. So I'm just ascertaining.
I am just laying the foundation to launch into my submission because
yes, but your foundation has a factual basis.
No, well, the basis of my foundation is based on what the complaint, the application is about. that what the application is about, having set out what the application is about, it is my
Yes, go ahead.
now, as I've said, having the applicants now have brought this application, the excellent application, seeking the following remedies: a declaration that the purported declaration of the election return votes made by the returning officer for election district number 4 of the Cooperative Republic of Guyana, dated the 5th of March 2020, by form number 24 of the Representation of People Act, general election, is in breach of the provision of the Representation of Peoples Act and is unconstitutional, unlawful, illegal, null, and void. So they're asking for declaration.
Who has something? There's a sound in here that is like a recording. Yes, Mr. Wilson.
Yes, the first is a declaration of the votes made by the returning officer for election district number 4 is in breach of the provision of the Representation of People Act and is unconstitutional, unlawful, illegal, improper, null and void, and of no effect. Second declaration, that the Guyana Election Commission is the only body constitutionally and statutorily authorized to declare the results of the general and regional election held on the 2nd of March 2020 in the Cooperative Republic of Guyana, pursuant to Section 96. There be no complaint that the Election Commission has made any declaration in the affidavit as to the general and regional elections held on the 2nd of March 2020. Thirdly, a declaration that Guyana Election Commission cannot legally, lawfully, or constitutionally declare the results of the general and regional election held on the 2nd of March 2020 in the Cooperative Republic of Guyana unless and until the returning officer or the deputy returning officer for election district number 4 and or the chief election officer complies with and ensures the compliance with the process set out by the provision contained in and the letter and spirit of Section 84 of the Representation of People Act. Fourthly, an order vacating, revoking, setting aside, and or declaring invalid the purported declaration of the election returns made by the returning officer for election district number 4 of the Cooperative Republic of Guyana, dated the 5th of March 2020, by form number 24 of the Representation of People Act, in respect of the vote cast in election district number 4 for the general and regional elections. An injunction restraining the officer Claremont Mingo, election district number 4 in the Cooperative Republic of Guyana, and the chief election officer Lowenfield, the Guyana Election Commission, jointly and severally, either by themselves, their servants, and or their agents, and or by each of them, from in any manner whatsoever, declaring the votes recorded for each list of candidates for the said district, before first complying with or ensuring the compliance of the process set out in Section 84 of the Representation of People Act. A mandatory injunction compelling the returning officer, Claremont Mingo, election district number 4 in the Cooperative Republic of Guyana, or the chief election officer, Keith Lowenfield, and the Guyana Election Commission jointly, severally, either by themselves, their servants, and or their agents, and or each of them to comply with this letter and spirit of Section 84 of the Representation of People Act. An injunction restraining the Guyana Election Commission, either by itself, its servants, and or agents, and each and every one of them, from in any manner whatsoever, declaring the total number of valid votes of electors with each list of candidates recorded in the national or regional elections, until and unless returning officer Claremont Mingo, district number 4, and the chief election officer comply and ensures the compliance of the process set out by the provision. The parties, the applicant went before Justice Navindra Singh and made an oral application. And Justice Navindra Singh granted the orders. It is hereby ordered and directed.
I'm sorry, Mr. Boston. I don't need you to read out all of
All right, granted certain orders.
Thank you very much.
All right, thank you. And I'm moving on now. Now, it is submitted that this court has no jurisdiction to entertain the application and grant the order sought on the ground that the question raised in the application pertain to a class of questions enunciated in Article 163(1) of the Constitution, exclusively within a special jurisdiction of the court, and must be presented by way of an election petition after the result of the election has been made. No jurisdiction. Article 163 of the Constitution establishes a special tribunal to deal with questions of this sort. The court has no jurisdiction to grant any injunction by way of equitable relief in the manner sought, which are ancillary to the main thrust of the plaintiff's application to restrain the CEO and others from continuing to conduct the elections or to conduct the election in a particular way. Article 163 of the Constitution states as follows: subject to the provision of this article,
Go ahead, Mr. Boston.
the High Court shall have exclusive jurisdiction to determine any question regarding the qualification of any person to be elected as a member of the National Assembly. We are not dealing here with the qualification of a person to be elected to the National Assembly. 163(1)(b) state, exclusive jurisdiction to determine any question, either generally or in any particular place, an election has been lawfully conducted, or the result thereof has been or may have been affected by an unlawful act or omission. Now, the question the applicant is asking this court to decide falls squarely within 163(b)(1), whether the election has been lawfully conducted or there is some specific illegality which affects the results or the outcome of the election. 163(4) states, Parliament may make provision with respect to the circumstances and in manner in which and the conditions upon which proceedings for the determination of any question under this article may be instituted in the High Court. An appeal may be brought to the Court of Appeal. Parliament has passed legislation to deal with how the question in relation to 163(1)(b)(1) should be determined. And that was made in the National Assembly Validity of Elections Act. Section 3 of the National Assembly Validity of Elections Act deals with the method of questioning validity of election. Section 3 states, any question referred to in Article 163(1)(a), (b), and (c) of the Constitution may, in respect of an election referred to in Article 62 of the Constitution, and with a view to securing appropriate remedial orders, be referred to the court, and shall thereupon be determined by it in accordance with this Act. Subsection 2 of Section 3 says, every such reference shall be by a petition hereinafter referred to as an election petition presented to the court in accordance with this Act. So, pursuant to Article 163, Parliament has passed legislation and gives a tribunal the special power to deal with any issue that arises under 163(1)(b)(1). And Section 5 of the National Assembly Validity of Election Act says, subject to this section, an election petition shall be presented within 28 days after the results of election out of which the matter in question on the petition arose are published in the official gazette under Section 99 of the Representation of Peoples Act. So, a petition, a challenge by way of a petition, can only come within 28 days after the results of the election of which the matter in question on the petition arose are published. Now, the question, when we look at the affidavit of Mr. Riaz Oladar, the affidavit of Mr. Oladar, the applicant, this is the trust or the substance of his complaint. I don't wish to recite earlier that he is an elector and he has
No, we don't need all of that, Mr.
No, we don't need all of that. I don't wish to go to that. Paragraph 11. He said the tabulation and verification process were conducted in the presence of all the contestant political parties and the international diplomatic and local observers, and the results were declared and announced without any objection. That is how he relates
Paragraph
to
11 in the applicant's affidavit.
Yes, this is what I have. Paragraph.
Or are you looking at just the applicant's affidavit doesn't go to a paragraph 11. It goes to paragraph 7. Paragraph 6, he recites what Ms. Barak told him.
No. The applicant. Roman numeral 11 is reciting what Ms. Savitri Sonia Parag has told him.
Yes, very.
Sorry. He said that this tabulation, he was told this tabulation and verification process were conducted in the presence of representatives of all the contesting political parties and the international diplomatic and local observers, and the results were duly declared and announced without any objection, protest, or challenge. To date, there has been no completed verification of the votes casted for election district number 4. I will go to 15. Over the next 72 hours after the close of polls, the verification and reconciliation process was disrupted and delayed on several occasions, and on all of these disruptions and delay have been attributed solely to the refusal, failure, neglect, or omission on part of the third name respondents, its officers, servants, and agents to conduct the process in an open, transparent, fair, and efficient manner, and in compliance with provision of the Representation of People Act. Election number 4 has 879 polling stations, and to approximately only 350 have been verified. Now, this is based on what was represented to Justice Singh, on which he granted those injunctions. He continued that on the 4th of March, GECOM representatives continued verification and reconciliation process, whereby officers of GECOM began verifying information from a separate sheet instead and in place of the statement of polls.
Which paragraph are you reading now?
Roman numeral 18.
18. Verify.
Whereby the officers of GECOM began verifying information from a spreadsheet instead and in place of a statement of polls, and this process disclosed major discrepancies between the figures recorded in the separate spreadsheet when compared to the statement of polls in possession of the contesting political parties. A strong objection from all contesting, that is 19, Roman numeral, a strong objection from all the contesting political parties except at noon. The verification and reconciliation process were halted. I'm now going to Romans 23. On the 5th of March 2020, the returning officer for election district number 4 attempted to declare the results for this district without any verification and reconciliation of more than 530 statements of poll. However, this process was halted after strong objection and protest from the observers and contesting political parties. To date, there has been no proper and lawful declaration of the votes for election number 4 in compliance with the provision of the Representation Act. As a result, the applicant obtained certain injunctive orders on the 5th of March 2020. The injunctive orders were duly served. The applicant hereby contends the last 29, Roman numeral 29. The applicant hereby contends that the purported declaration of votes made by the returning officer for election number 4 is unconstitutional, null and void, and of no legal effect. So what they're saying here, this election, the declaration of the result for Region 4 was not made in accordance with the election law. There were allegedly a spreadsheet from which a person from GECOM was reading, and that figure that was read out did not correspond to the statement of polls held by the various political parties. So what they're calling into question there that the results for Georgetown, which has been declared, is affected by an unlawful act or omission. And that falls within the teeth of 163(1)(b). Miss Sonia Parag affidavit, the first affidavit, obviously is the facts in that affidavit is what were recited before Justice Navindra Prasad that led him to grant the injunction.
Navindra Singh, you mean? You said
Navindra Singh. No, this is what Ms. Parag said.
Well, unless you're going to Ms. Parag's supplementary affidavit, hers is just a repetition of what is in Mr. Poligar's affidavit.
Of course.
So I don't really, I don't think you need to have to recite the paragraphs again, because it's almost mirror for mirror.
But what is in what they're complaining of what Ms. Parag is actually saying.
You're speaking about the original affidavit?
I'm now speaking about our second supplementary affidavit.
Okay, fine.
Paragraph 5. She said, I now say, in relation to paragraph 7 of my first supplemental affidavit, that it was Mr. Keith Lowenfield, Chief Election Officer, who informed myself and representative of the other contesting parties, and in the presence of international observers, that the spreadsheet produced by GECOM official contained the vote recorded on the statement of poll. This is very interesting. The complaint is that the spreadsheet, when someone from the Election Commission was calling out information from the spreadsheet, it did not correspond with their statement of poll. And there were no movement, they're saying, in their presence to verify the remaining statements of poll from 500 plus polling stations. Obviously points to the fact that the result declared obviously is not the correct results. That is what they're saying. And the act of using the spreadsheet which does not confirm with their statement uphold that the result declared for Region 4 has been affected. That is summary of the argument, has been affected by some unlawful act or omission. So they are seeking this redress. Now, when we look at the election law in Guyana, as set out in the Representation of Peoples Act, the National Assembly, Validity of Election Act, and the Constitution, the election law in our country does not contemplate there should be two attacks on matters connected with election proceeding. One while they are going on, while the election is going on, by seeking judicial review proceedings, and another after they have been completed by means of an election petition. It's not a two-stage, it doesn't contemplate a two-stage process. If it had contemplated a two-stage process, the framers of the Constitution would not say to determine any question either generally or in any particular place an election has been lawfully conducted. They would have added not only the past tense, an election has been lawfully conducted. They didn't say, or an election which will be lawfully conducted. They deal with the past tense election which has been lawfully conducted. They didn't deal with a future tense or if the election was unlawfully conducted. If there were to be a two-stage process, obviously the framers would have included that language. Now, this issue has engaged the attention of our courts on several occasions. I would like to refer to the case of Gladys Petrie and others, and the Attorney General and others. 1968 14 West Indian Report at page 292. Now, the facts are, I guess you're
yes, thank you very much.
Yeah, you are acquainted. But let me just but in essence, the plaintiffs brought proceedings to prevent the chief election officer from conducting the election on the day appointed by the Governor General for election to be conducted. They took out a summons in which they sought certain interlocutory orders to prevent the chief election officers and some other officers to restrain them from conducting, holding, or administering an election to the National Assembly on the basis of the registers aforesaid. A preliminary objection was taken by the Attorney General, Mr. Ramphal, and the court held that by virtue of Article 71 of the Constitution, which is casting the identical language as Article 163 of the current Constitution, Parliament has conferred an exclusive jurisdiction on the High Court to determine certain questions appertaining to election to the National Assembly. And the court had no jurisdiction to determine the matters raised as they pertain to the class of questions enunciated by Article 71. So as long as the matters raised pertain to the class of questions enunciated by Article 71, such matters must be raised by way of an election petition after the result of the election has been made known. Mr. Ramphal took a point in limited that the court has no jurisdiction. It has to be dealt in a special court. It was argued by counsel for the applicant that if before an election something is wrong, in any system of justice, a party must have a right to challenge it immediately and not to have wait until more irreparable harm has been done. So if the plaintiff says if something has happened in the course of the election, you don't have to wait until some further harm is done. You have a right to come to the High Court and deal with it. Chief Justice Bullard, in analyzing Article 71, had this to say. Of course, he rejected the argument of the claimant that they can come before in the ordinary jurisdiction of the court. On an analysis of the articles in relation at page 299, he said on analysis of the articles in relation to the matters which concern us here, it is clear that Parliament is here conferring an exclusive jurisdiction on the High Court to determine certain questions. These questions around the qualification of any person to be elected as a member of the National Assembly, whether generally or in any particular place an election has been lawfully conducted, or the result of the election affected whether the seats in the National Assembly have been lawfully allocated, or a seat has become vacant, or any member of the Assembly is required to cease. In paragraph 3, provision is made for an appeal to the Court of Appeal from the decision of a judge in chamber of the High Court granting or refusing leave to institute proceedings. And he analyzed and he went all along and he cited several cases in support of the position, and he concluded, unless and until disqualification had to be established in only possible manner, it was not possible to argue its consequences. Then at page 302, the question remains whether an interlocutory injunction can be obtained in these proceedings, indeed in any proceedings. And I accept the submission by the Attorney General that on a fair construction of Article 71B, that is our 163B1, the language used does not permit of an interlocutory injunction being granted to prevent election being held on the appointed date, and similarly, by party of reason, can be granted to prevent the chief election officer from continuing in his conduct of an election which is not over. I accept the analysis of the relevant paragraph that the question which is entrusted to the court is whether an election has been lawfully conducted. And what they are complaining about, what the applicant is complaining about, whether what was done, the declaration of Region 4 results, was lawfully done. It has to be noted that the past tense is used and not the future tense. And it seems to me that if the framers of the Constitution intended the relief could be sought by way of an interlocutory injunction, the paragraph should have read whether an election has been lawfully conducted or will be lawfully conducted. I agree with the submission that the question which the court has to consider on the paragraph are whether there is some general illegality either affecting the whole election or the election held in some particular place, or in the absence of a general illegality, whether there has been some specific illegality, being either an act or an omission which affects the result of the election. And that is what they say in the act, or the omission of Mr. Lowenfield and others to verify in their presence obviously is a specific illegality and it affects the outcome. It seems to me that the word election is used in the paragraph in its wider sense to include the whole process of an election. Section 12C, 12 Hansberry Law, second edition. Where are you
reading from, Mr.?
I'm reading from page 302, paragraph I.
Oh, you've gone on to I. Very well.
Yes. Says C, 12 Hansberry Laws, second edition. Page 237 to 238, wherein it is stated that although the first formal step in every election is the issue of the writ, the election is considered for some purposes to begin at an earlier date. It is a question of fact in each case when an election begins in such a way as to make the parties concerned responsible for breaches of election law. The test is whether the contest is reasonably imminent. And he cited with approval the dicta of Justice Fazal Ali in Punaswamy and the Chief Election Officer Now, in Punaswamy's case,
But just let me ask you this question, though, Mr. Boston.
Yes.
You just mentioned, so the applicant is saying the acts on omissions to verify, I guess it's SOPs. Well, I don't know, verify what?
Verifying the purported 500 plus statement of poll, or the statement of poll from the 500 plus stations.
Stations, or just a minute. In their presence. So the applicant is saying the acts and omissions to verify the SOPs from the 500 plus polling stations in their presence is a specific illegality.
Yes, that's the only inference they're complaining.
So they're saying that Section 84, my understanding of their affidavit, or some of their affidavits, or some of the content of their affidavit, let me put that way, is that Section 84 requires the presence of certain persons during the addition of the SOPs. And they're saying that for part of that process, those entitled persons were not present.
That's
their contention.
That is the basis of their contention, that you have not been conducting this thing in accordance with the election law. And now,
but if there's a process, I'm just trying to find out, if there's a process issue, and I will go through P3, but if there's a process issue that has not been complied with, never mind what the results are, that's of little consequence. If the process issue has not been complied with, the question is whether a person can come to the court to say the process has not been complied with. You're not concerned with the result, just the process.
It is my submission, they cannot. It has to with the outcome. They are not without redress, because on their dissatisfaction, if they're saying the election has not been conducted in accordance with the election law, then when they file an election petition, Section 19 of the National Assembly Validity of the Election Act says what the judge can do. Production of election documents. And Section 19 says...
Yes, but to my mind, that's getting into that realm. And I mean, I know what the affidavits are saying, and to my mind, in some respects, they cross the line. It's not a question of whether the production of any statements of poll. It's just a question of, was the addition done in the presence of the persons entitled to be there?
No,
at least that's how I'm looking at it, subject to what the applicant's counsel has to say, because the affidavits are quite expansive. But to my mind, that's the narrow issue.
No, all the affidavits, if you sum it up, are pointing to the fact that some specific illegality has been committed, in the sense that they were not given an opportunity to do what they're saying they're entitled to do,
Okay. Yes, Mr. Wilson.
yes. So I'm saying that if they're dissatisfied, this declaration, they have all said this declaration has been made.
Well, I found the affidavit a little confusing in that regard, but I'll get to that when I come to the applicant's counsel. But go ahead.
So as I was saying, they are not without redress if they come by way of an election petition. Production of election documents, Section 19 says, any document or paper relating to an election and required to be kept thereafter in safe custody by the Chief Election Officer under Section 1 or 2 of the Representation of People Act may be inspected or produced under an order of the court for the purpose of an election petition, and the order may be made by a judge on his or her being satisfied by evidence or note that such inspection or production is required for the purpose aforesaid. So, they have redress. Now, as I was citing the case of N.P. Punaswamy versus the returning officer of India, 1952, AIR at page 64, or 1952 Supreme Court report at page 280. No.
You cited from the case directly, or you're taking the quote from P3? Because it's at 303 at P3.
I am going to deal with the report.
Okay.
In that case, Punaswamy wanted to be a candidate for the election of the state of Madras. Punaswamy submitted his nomination form and his form was rejected. He did not approach the court pursuant to section Article 329 of the Constitution of India. He approached the court by Article 226, seeking certiorari. He was told by the Supreme Court, and they analyzed all the cases, that the court has no jurisdiction. He has to come by way of Article 329B. Article 329B of the Constitution of India provides that no election to either House of Parliament or to the House or either House of the Legislature of a state shall be called into question except by an election petition presented to such authority and in such manner as may be provided by or under the law made by the appropriate legislator. The Representation of Peoples Act 1951, which made detailed provision for election to the various legislatures of the country, although contains a provision that no election shall be called into question except by an election petition presented in accordance with the provision of Section 2329. The court held that, in view of provision of Article 329B of the Constitution and Section 80 of the Representation of People Act, the High Court had no jurisdiction to interfere with the order of the returning officer. The word election has by long use in connection with the process of selection of proper representatives in democratic institutions acquired both a wide and narrow meaning. Having regard to the important function which the legislator have to perform in democratic countries, it has always been recognized to be a matter of first importance that elections should be concluded as early as possible according to time schedule, and all controversial matters and all disputes arising out of election should be postponed till after the election are over, so that the election proceeding may not be unduly retarded or protracted. In conformity with this principle, the scheme of the election law in this country, as well as in England, is that no significance should be attached to anything which does not affect the election, and if any irregularities are committed while it is in progress and they belong to the category which class under the law which election are governed, will have the effect of vitiating the election and enable person to be affected to call it in question. They should be brought up before a special tribunal. So this is what, and they went on further to say, the right to vote or stand as a candidate for election is not a civil right, but is a creature of statute or special law, and must be subject to the limitation imposed by it. Strictly speaking, it is the sole right of the legislature to examine and determine all matters related to the election of its own members. And if the legislator takes it out of its own hands and vests it in a special tribunal, that special jurisdiction must be exercised in accordance with the law which creates it. And the Indian Supreme Court relied on an old case, say where a right or liability is created by a statute which gives a special remedy for enforcing it. The remedy provided by the statute only must be availed. So if the National Election Validity, the National Assembly Validity of Election Act gives us, created the way in which this remedy should be enforced, it must be enforced using that statute.
Yes, Mr. Boston, it is a preliminary point, so it's time to wrap.
No, I'm getting there.
No, time to wrap. You're getting there?
I'm on my, that's what I'm making my presentation.
I understand that, Mr. Boston. How much longer do you have?
About 20 minutes or so now.
3 o'clock. It's 15 minutes.
Now, in Petrie, the court concluded, Bolos, Chief Justice said.
Where are you reading from?
I'm reading from page 305.
At which letter?
In the result.
No, which letter are you reading from?
From letter
E.
F.
Yeah, okay, I found it.
In the result, I must accept the submission of the Attorney General on the first point as being sound, and refuse to entertain this application on the ground that this court has no jurisdiction, since the question raised in the summons pertains to a class of questions enunciated by Article 71 of the Constitution exclusively within a special jurisdiction of the court and must be presented by way of an election petition. Yeah, you're going to get my chips. The same approach as to confining yourself to the statute that creates and the remedy was enunciated in Christopher and the Attorney General.
Which one of them?
Leader, that is CCJ 10, 2019. In that case,
You have the full citation. You have the full citation because you just.
I give you the citation, 2019 CCJ 10.
10.
In that issue, Your Honor, you recall that we came before you and said Charandas was not lawfully elected because he held dual citizenship. And we discovered that some years after he was elected a member to the National Assembly, and you rightly tell us, no, time has gone, we have to come by way of an election petition because Article 163, 1A, if you are challenging a person's right to be a member of Parliament, you have to come within 28 days after the result was declared. And this is what the court said at paragraph 40. There are two important policy reasons for the Constitution denying the court an inherent jurisdiction in this realm and allowing that jurisdiction to specifically conditioned by rules laid down by Parliament. Firstly, as previously indicated, this is a jurisdiction that concerns membership of Parliament. In this case, this is a jurisdiction that concerns whether an election has been lawfully conducted. As an element of separation of powers, the Constitution recognizes it is Parliament and not the court under any inherent jurisdiction of the court that should be at liberty to define the contours of a jurisdiction that peculiarly concerns membership of Parliament. Secondly, as Bowler CJ stressed in Petrie, it is in the public's interest that the validity of an election and hence membership of Parliament should be quickly determined according to strict rules and procedures that are predetermined by Parliament. Now, and at 41, the court said, under the existing rules prescribed by Parliament, therefore it matters not that the election date has long passed and the information about the member's disqualification did not surface until after the time set out by Parliament, nor can a claimant approach the court by a method other than prescribed election petition. The National Assembly Validity of Election Act provides a complete code for challenging the validity of an election on the ground that the person is not qualified to be elected. And by parity of reason, I submit that the National Assembly Validity of Election Act provides a complete code for challenging whether an election has been violently conducted. The position taken in P3 was also followed in GECOM, Singh, and another, and Butler. And GECOM and Butler is Guyana Law Reports of Guyana, 1973. Briefly, I will just say something about that. The President of Guyana issued a proclamation dissolving Parliament and a fixed date for election of members of the National Assembly. The defendant is the Chief Election Officer. The plaintiff brought an action against the defendant in his capacity as the Chief Election Officer, in which they sought declaration that certain election laws made under the Constitution of Guyana were constitutional, unconstitutional, illegal, ultra-virus, void, and of no effect, and injunctions to restrain the defendant from performing certain acts as election officer. They also filed summons in which they sought certain interlocutory order to restrain the defendant from performing certain acts in relation to the pending elections. This decision deals with the summons and matters in connection therewith as a question of jurisdiction of the High Court to grant the remedy sought was raised in limine. The election commenced with the issue of the proclamation by the President, and that by virtue of provision of Article 71 of the Constitution, the High Court of Guyana has no jurisdiction to grant an injunction, but only to deal with those matters specifically delegated to it by Parliament. And the only matter the High Court has specifically to deal with is in an election petition, whether the election for the division of District 4 has been lawfully conducted, or whether there were any specific illegality which was done by some member of the Commission which affects the results. He went on further to say that to grant the equitable remedy of an injunction will be a negation of Article 67 of the Constitution, which is the supreme law of Guyana. The defendant, being a public officer in the service of the government of Guyana, is the same as a servant of the Crown Proceedings Act, and therefore cannot restrain by injunction from carrying out his statutory function. To grant an injunction would mean that the court would be making an interim declaration that the legislation dealing with the election is invalid, and this court will not do, for the main issue will not have been determined. While the court can grant an interlocutory injunction, which will have the practical effect of granting the sole relief claim, the court will not do so. And it respectfully submitted that the injunction granted by Justice Navindra Singh certainly amounts to granting the relief claim by the applicants. And as I said, that mandatory injunction granted by Justice Singh is to restrain the Chief Election Officer from carrying out his function pursuant to the election laws of Guyana.
Yes, thank you very much, Mr. Yes, Mr. Mendes.
Thank you very much, Milady. The question which my learned friend has raised in his point in limine is whether the questions which the applicant in this matter is asking the court to determine falls within a class of questions which the legislature has said can only be dealt with by this court on an election petition brought after the election has been concluded and the results declared. In other words, after a government has already been installed. That's basically what the learned friend says is the question. We respectfully submit that the questions raised do not fall within that class. The question raised do not challenge the results of the election because the results of the elections are not yet known. The questions raised do not challenge the election itself. What these proceedings seek to do is to progress the election, to facilitate the election in accordance with the law, irrespective of what the result might be. Indeed, milady, I believe that the applicant's position in relation to my learned friend's point in limine is reflected in the question that you have asked my learned friend as to whether this is not a question of the procedure to be followed rather than the outcome of the entire process. But my lady, in order to appreciate what question is actually before the court, I'm proposing to structure my submissions in this way. First of all, I will take you to the relevant provisions of the Representation of the People Act, which will give my lady an idea of exactly what the complaint is, as it were, and therefore what the questions are that the court is being called upon to deal with. Then I will take you to the provisions of the Constitution and the National Validity Act to determine exactly what it is that the legislature has said must be brought by way of an election petition. And then I will go to the authorities, that some of my learned friends' authorities as well, which seek to interpret the National Validity Act or similar legislation in order to determine what types or classes of cases must be brought by way of the election petition. First of all, my lady, if I may ask you to have before you the Representation of the People Act. Do you have a copy?
Yes, I have.
I'm much obliged. And if I could take you to section 83 of the Act, which deals with what is to happen upon the closing of the poll. The internal number of the Act is page 103 in section 83. I'm assuming that your version is the same as mine.
Yes,
Yes, so section 83 says, 1, the presiding officer...
Mr. Mendes, I really don't want you to read it. It's a very long section. So just...
I'm not taking you through the entire thing, milady, I promise.
But just tell me if you want...
It says that the presiding officer, as soon as practicable, after the closing of the poll, in the presence of such of the persons entitled under section 79(1)(b to be present as attend, shall, and then there are a number of things that are listed that the presiding officer shall do. I am most interested in subsection 9A, which says, well, I should take you to 9 first of all, subsection 9. Are you familiar?
Yes, I am.
Thank you. It says, after the completion of the counting, the presiding officer shall complete the ballot paper account, intended ballot paper account in Form 23, the statement of poll in Form 23A, and prepare and certify a sufficient number of copies of the same for distribution as follows. Returning officer, assistant presiding officer, duly appointed candidates or polling agents, and the chief election officer. So you have the statement of poll in Form 23A being prepared in sufficient number of copies and handed out to all of these persons. And then you have 9A that says the statement of poll prepared in accordance with subsection 9 shall be posted in a conspicuous place outside the polling place as conclusive evidence of the result of the election for that polling place, unless there is a recount of the votes. So what that is saying is that that statement of the poll, which is put in a conspicuous place, is conclusive evidence of the result of the election. Now, my lady, that means that once that statement of the poll is prepared, is distributed as indicated, and is put in a conspicuous place, the public in general is provided with the means of knowing what the result of the election is if they are able to collate all of the statements of poll together and add them up. They will be able to determine exactly what the result of the election is. In other words, the result of the election is made public at that point in time, even though the public may not be able to collate it themselves. In this case, the People's Progressive Party, Civic, did in fact do that collation, as Ms. Paraga said in her...
Yes, but to be very honest, Mr. Mendes, I think that is, well, subject to what you have to say, to my mind, that there is crossing over into the issue of an election petition.
Sorry, Milady,
that issue is crossing over to the issue of what should be in an election petition. When you get into, this is what our statements of poll say, and this is what somebody else says, and this is what, I think that's the thin line.
Well, I'm citing it for a purpose, Milady, only for this purpose, to indicate that when you look at this, when you add up the statements of poll in relation to District 4, for example, that the statements of poll which were distributed at that point in time, it shows a particular number. When you compare it with what Mr. Mingo apparently produced at the end of the purported Section 84(1) count, there is a significant difference.
What I'm saying to you is I have a difficulty with getting into that.
Milady, I will indicate the purpose of that comparison in a minute, because it goes towards the procedure to be followed. If I can do that very quickly, Milady, to illustrate what I'm talking about. If you look at Section 84(1) of the Act, it says that as soon as practicable, after the receipt of all the ballot boxes and the envelopes and packets delivered to him in pursuance of Section 8310, the returning officer shall, in the presence of such persons entitled under Section 86(1) to be present and as attend, ascertain the total vote cards in favor of each list in the district by adding up the votes recorded in favor of the list in accordance with the statements of poll, and thereupon publicly declare the votes recorded for each list of candidates. So what it's saying there is that you must add up what you see on the statements of poll. And this process must be done in the presence of the persons entitled to be there, stated in section 86(1). Now, my lady, subsection 1A is important because it says, where an election officer for a polling district discovers a material error on the statement of poll from a polling station for that polling district, he shall inform the presiding officer for that polling station forthwith, and the presiding officer, the statement of the poll has not yet been sent to the returning officer. In the presence of the persons who signed the original statement of the poll, shall prepare a corrected statement of the poll, signed by himself and the original signatories, etc. And then B says, where the mistake is discovered when the statement of the poll is in the possession of the returning officer, the presiding officer shall be informed of the mistake, etc. So there's a process that is set out to be followed in subsection 1A, where a discrepancy is discovered. Now what I'm saying, my lady, is that the evidence that has been put before you, which is that the collation of the statements of poll in relation to District 4, after the statements of poll were put up in a conspicuous place, is significantly different from the Mr. Mingo's results in that document that we have exhibited, which indicates a discrepancy. So if there's a discrepancy, then section 1A dictates what is to happen when you discover that discrepancy. But of course, the discrepancy in the first place must be discovered, if it exists at all, in the presence of persons who are entitled to be there in accordance with section 86(1). So the evidence indicates that there is some discrepancy, and section 84(1) and 1A dictates the procedure that you must follow to deal with those discrepancies. This is, of course, on the assumption that the discrepancy between the statements of the poll, that is to say the carbon copies that are provided to the parties, and the statements of the poll that presumably were in possession of Mr. Mingo, is a genuine discrepancy and not a contrived one. That is the assumption, of course, of the submission that I am making. The point in any event is that there being evidence of a discrepancy, 84(1) and 84(1A tells you how you must resolve it. What the evidence is that there were 874 ballot boxes in 879, in relation to District 4. 421 of them were dealt with in accordance with 84(1), that is to say that the returning officer added up the figures found on the statements of the poll, and the evidence is that there were only minor discrepancies between the original statement of the poll and the copies that the parties had, and those minor discrepancies were resolved by calling in the presiding officer. In other words, those minor discrepancies were resolved in accordance with section 84(1)A. The problem arises in relation to the remaining 458, I think it is, if my math serves me right, 458 other polling boxes. The evidence is that after midnight on the 5th of March, that is 2 days ago on Thursday, the exercise in relation to the 421 boxes had been completed, and then at around 3 a.m. the entire process was suspended and people were to come back. By the time Mr. Mingo returned to the appointed place around midday, he then declares, well, I am going to make a declaration. So that the process, the evidence is that the process in relation to those 458 boxes under 84(1) and 84(1)A, that process was not followed in relation to the 458 boxes. I'm sorry if I'm forgetting the exact figure. The process was not followed. And it appears, and I'm saying it appears, that the declaration was made under 84(1), despite the fact that that process was not followed. What the applicant is saying in this case is, and what the applicant is asking this court to do is to direct that that process be followed. It's as simple as that. Follow the process in relation to the remaining 458 boxes. Do the adding up of the votes on the statements of poll in the presence of persons who are entitled to be there. If there are discrepancies, resolve them in accordance with 84(1)(a), and then when you are completed with that process, you then make your declaration of the result of District 4. Once that is done, of course, my lady, then there are other processes thereafter. But the purity of the election process, the transparency of the election process requires that it be done in accordance with 84(1) and 84(1)(a), and the evidence is that it has not been done. Maybe after that is done, that is after the 84(1) and 1(a) process is completed, you then have 84(2). 84(2) says that where before 12 noon of the day following the declaration under subsection 1, any counting agent for the district does not request the returning officer to conduct a final count of the votes counted by the presiding officers in district under section 83, the declaration of the votes obtained by the list under subsection 1 shall be final. So it becomes final if by midday of the following day a request for a final count is not made. Now, of course, it means, my lady, that the finality of the list cannot be determined until 12 midday on the following day. And it means that you cannot issue the final Form 24, which is the form that you serve on the Chief Elections Officer after that process is completed. You cannot do that until midday of the following day. What appears to happen, and I'm saying appears because we're not clear on exactly what has happened, is that having declared to the parties assembled on the 5th of March after midday that he was going to make a declaration without engaging in the process in relation to the 558 ballot boxes, there then appeared on social media this Form 24 with his signature on it, which doesn't indicate that it is a District 4 declaration, but nevertheless it has certain figures on it. But it is headed Form 24. But we hadn't gotten to the Form 24 situation as yet, because Form 24 can only arise after the 1 hour period, after the 1 day period has elapsed by midday of the following day. But that Form 24 is issued since the 5th of March. So that the process again has not been followed properly in relation to the declaration of the result into District 4. Again, what the applicant is seeking to have done in this case is that the process be properly followed so that whatever the result of the election is, we can confidently say that it has been carried out in accordance with the law, and the public can be assured that the result is a due result carried out precisely in accordance with the obligations imposed upon the election officials. My lady, the other issue that arises on the evidence again is that on the assumption that there was a declaration made, a proper declaration made on the 5th of March, Mr. Ramson, the counting agent for District 4, made a request for a final vote under 84(2). And if that request was a proper request, on the assumption that the declaration that was made on the 5th of March is a proper declaration, then we can't get to the declaration of a final result either until the process under Section 84(2) is then carried out. And Section 84(2) is very clear. Once you make a request for a final count, and if I may remind you, it says, where any counting agent for the district seeks a final count of the votes already counted by the presiding officers of the district under Section 83, the returning officer shall count such votes in accordance with the provisions contained in the following subsections and Section 87, and on the basis of such recount, confirm or vary the declaration of the votes recorded in the district for each list of candidates under subsection 1. So that process now is not the same process in the 84-1. 84-1 is just a matter of adding up what you find on the statements of the poll. This process actually involves the counting of the ballots. You open up all the sealed envelopes, you take out the ballots, and you do, in other words, exactly what the presiding officer did. You count the ballots and you determine whether what is stated on the statement of the poll is accurate. Lady, I will not take you through the entire section 87, but it is set out there in great detail exactly what the final count entails. Again,
but I'm thinking though, Mr. Mendes, that process over.
Sorry,
that also crosses over the line to the elections petition.
No, lady, it deals with process, because what we're saying is that that in order for there to be a due election under the Act, irrespective of what the result is, a certain process has to be followed. So we are only concerned with the process. And we're saying, if it is that there has been a declaration under 84-1, and if there has been a request for a final vote under 84-2, then the Act sets out exactly what the process is that must not be now be followed to get to a final result. So all we are, the questions that we are raising in this case, the orders that we are asking that the court make is geared towards facilitating or ensuring that there is a proper election, whatever the result might be.
Now, if I may just quickly, Milady, complete this part of my submission by directing your attention to what happens after the Form 24 is issued by the returning officer. Very quickly, I take you to Section 96, which says that the Chief Election Officer shall, after calculating the total number of valid votes of electors which have been cast for each list of candidates, on the basis of votes counted and the information furnished by returning officers under Section 8411, ascertain the result of the election in accordance with Section 97 and 98. So the result of the election is not determined until the Chief Election Officer does the counting up that he is now required to do by Section 96.1. Contrary to what my learned friend says, what Mr. Mingo did, whatever he did, on the 5th of March, is not determine the result of the election. The result of the election is determined by the Chief Elections Officer under Section 96.1. And then 96.2 says that the Chief Election Officer shall prepare a report, manually and electric form in terms of Section 99, for the benefit of the Commission, which shall be the basis for the Commission to declare and publish the election results under Section 99. So the Chief Election Officer prepares the report, having totaled up all of the votes right across the various districts, and prepares that report and sends it to the Commission. And then it is under Section 99 that the result of the election is then declared. And you'll see 99 says, as soon as practicable, but not later than 15 days after election days.
But I'm just going back to 163. I know you said you were going to come to the Constitution.
Yes,
but when you mentioned that Mr. Mingo did not determine the result of the election.
Yes.
163, 1B, I.
Yes.
Speaks to whether in any particular place, so one would think the District 4 is a particular place, the result thereof has been or may have been affected by any unlawful act or omission.
Yes, but we haven't gotten to the result as yet, milady. So we can't be challenging the result. The result is not known until the Chief Election Officer declares the result and presents a report to the Commission. And then the Commission carries out its exercise, and under Section 99 says, as soon as practicable, but not later than 15 days, the Commission shall publicly declare the results of the election and shall cause to be published in the Gazette a notification thereof specifying the number of votes cast, etc., etc. So that is the end of the process here. The result of the election, determined by the Chief Election Officer, is now declared by the Commission.
So you're saying the result is only determined by the CEO pursuant to which section?
Pursuant to Section 96.
96. Yes, okay.
Now, lady, so with that in mind, if I can if I can take you back to the Constitution itself, where my little friend more or less started. And as you were just reading, Milady, Section 163, vests exclusive jurisdiction in the High Court to determine the questions that are there listed. Now, the Constitution itself, although it says that the High Court has exclusive jurisdiction to determine these questions, does not say itself how those questions are to be determined. It doesn't say, the Constitution does not say, that those questions are to be determined by an election petition brought after the results of the election have been announced, or at any particular time, or at any particular way. The Constitution leaves it for the legislature to prescribe, and that is in subsection 4 of section 163, as my little friend has already read to you. And Parliament has in fact so prescribed under the National Election Validity Act. Now, my lady, it's important to appreciate that what we are now construing is an ordinary act of Parliament, that is to say the National Assembly Validity of Elections Act, and not the Constitution itself. It is this ordinary act of Parliament that the learned friend is saying ousts the jurisdiction of the court to exercise its ordinary supervisory jurisdiction of the acts of public officials. Now that is...
I always thought, though, that while it might be circuitous, that whilst that's an ordinary act, because it flows from the Constitution, that in effect, the question is, are you abiding by the Constitution in following the provisions of the Act, or not following the provisions of the Act?
Well, no, my lady, because as I pointed out, the Constitution does not say how it is that you are to go about exercising jurisdiction.
No, it says you have to go, it says Parliament will provide.
It says Parliament will provide, and Parliament has now provided.
Yes.
Parliament has not provided by amending the Constitution, and because if you amend the Constitution, you have to do that in a certain way. Parliament has provided the process by way of an ordinary act of Parliament. And what my learned friend is saying is that by this ordinary act of Parliament, Parliament has ousted the jurisdiction of the court to review the procedure that is being followed by election officials in the exercise of your normal supervisory jurisdiction. That is important, my lady, because it means that, in accordance with the ordinary canons of construction, that you have to interpret the National Elections Validity Act strictly or narrowly, and if there's any doubt as to whether the court's ordinary supervisory jurisdiction has been ousted, then you ought to interpret the Act in favor of retaining your jurisdiction and not having it ousted. That is normal, that's the anismonic principle, my lady. That is the principle that applies in relation to all ouster clauses. So I'm saying that you must approach the interpretation of this legislation in that way. And I'm saying that, my lady, because when you look at section 3, it says, any question referred to in Article 163(1)(a), (b), and (c) of the Constitution may, in respect of an election, referred to in Article 62 and with a view to securing appropriate remedial orders, be referred to the court and shall thereupon be determined by it in accordance with this Act. So we now have to determine exactly whether the questions that have been asked in this case fall within the category of questions referred to in 163(1)(a), (b), and (c), but not without assistance. The assistance that we do have in interpreting in effect section 3, which incorporates the wording in section 163, is the rules themselves, which have been enacted by Parliament under the Constitution as well. This is the National Assembly Validity of Election Rules, which is in the form of subsidiary legislation at the back of the Act itself. But if you look at that if you look at those rules, it says that they were made under 163 of the Constitution. So this is Parliament itself providing for the procedure that it is allowed to provide for in accordance with 163.4. So if we look at that, Milady, it provides some assistance as to exactly what Parliament intended. If you look at Rule 3,
Yes.
it says, except by way of an election petition for redress in conformity with the Act, there shall be no reference to the court of any question regarding the qualifications of any person to be elected as a member of the National Assembly. Now, this is not such a case. Or whether the result of an election may have or has been affected by an unlawful act or omission. Now, that is not the case here because we do not yet know the result. As I've indicated, Milady, the result is only known after the Chief Elections Officer tallies all of the votes. Are you with me, Milady?
Yes.
And then lastly, or whether the seats, sorry, not lastly, second to last, whether the seats in the Assembly have been lawfully allocated. That is not the question that is raised in this case. But then it says, or whether any elections, the results whereof are declared by the Elections Commission in pursuance of Section 99 of the Representation of People Act, has been lawfully conducted. Those are the questions, those 4 questions, that Parliament is saying cannot be entertained by this court except upon an election petition. And of course, the questions that are raised in this case do not fall within that last category because the results of the election have not yet been declared by the Commission in pursuance of Section 99 of the Representation of the People Act.
Yes.
The point being, my lady, that Parliament, in seeking to control the way in which the court was to exercise its jurisdiction on Section 163, passes Section 3 of the Act itself, but it also passes Rule 3 of the rules, in which it addresses very clearly and directly what the court must not do, or what jurisdiction the court does not have. But it is addressing it very clearly and directly in a way that Section 3 of the Act does not address. Section 3 of the Act says that the questions under Section 163 may be pursued by election petition. This one now says what you must only pursue by an election petition. And those 4 questions are not the 4 questions that are involved in these proceedings, my lady. Now, my lady, again respectfully, that is an interpretation that is available, and it is an interpretation to be preferred because ordinary legislation is to be interpreted in such a way as not to oust the jurisdiction of the court, supervisory jurisdiction of the court, if such an interpretation is available. That's a general proposition upon which we rely, my lady. But, my lady, there is, I respectfully submit, further authority that supports the interpretation that we ask you to put upon the legislation. I will ask you first of all to look at the decision of the CCJ that my learned friend referred you to. I'm not going to repeat the passages that he did refer you to because, of course, this case was only dealing with the challenge to the qualifications of a candidate, not to the other types of questions that can arise. But it is important to appreciate that the reason why the court came to the conclusion that its jurisdiction was ousted is on the basis of its interpretation of the legislation itself. If you look at paragraph 36 of that judgment, I think you've been handed up a copy. Mr. Mendez, SC, cited a variety of cases showing that the election petition procedure is intended to be an exclusive one, and that the court has no jurisdiction to consider the question of the validity of an election by any other means. This, in fact, is also clearly stated in Rule 3.1 of the National Assembly Validity of Election Rules, which Justice Saunders then quotes. So that point is made clear. Now, my lady, it's also important to bear in mind what Justice Anderson also said in relation to the ouster of the
So that's
jurisdiction.
paragraph 46 per Justice Saunders.
Yes, please, my lady. And I'll ask you to look at paragraph 92 of the judgment of Justice Saunders, where he makes this very important statement. The Constitution was never meant to be a suicide pact. The court is above all else the guardian of the Constitution and the guarantors of the rule of law. The Remedies section of the Constitution gives the court the widest powers to address constitutional infractions and to uphold constitutional integrity. I concede that the circumstances in which a court is entitled to disregard the procedures and timelines specified in election legislation in favor of upholding the fundamental tenets of the Constitution regarding eligibility in Parliament are not entirely clear and require further thought. However, I consider that one circumstance where this extraordinary jurisdiction may be warranted is where parliamentary membership was obtained by intentional and fraudulent means. In the accepted vernacular of the law, fraud unravels everything. So, my lady, what he is envisaging is there may be a situation where fraud has been committed in the course of the process of determining the results of the election, and the court may be minded to intervene in those circumstances, lest you find that a government that the public does not want is foisted upon it because an election official has effectively committed a fraud. And therefore the court must be wary of that eventuality, and therefore must be even more minded to ensure that the procedures that are set up under the Representation of the People Act to ensure that that fraud is not committed are scrupulously followed. My lady, I rely next.
I thought you were going to Justice Anderson.
That was Justice Anderson.
Paragraph 92?
Paragraph 96 was his judgment.
So 46 is Justice Saunders. Okay,
Justice Saunders.
I misheard you.
Yes, my lady. If I may handle three cases, I'm going to refer you to this.
Thank you.
This is a decision of the Supreme Court of India, my lady. The Election Commission of India through Secretary versus Ashok Kumar and others. The judgment is dated the 30th of August 2000. And you will see at page from around page 6 of that printout, the court is examining its previous decisions pertaining to the question of the ouster of the court's jurisdiction in relation to the election question.
This is, okay, 2002.
This is decided in 30th of August 2000. And in the last full paragraph on that page, my lady, where it says, vide paragraph 29 in Mohinder Singh Gill's case, it says, the Constitution Bench noticed two types of decisions and two types of challenges. The first relating to proceedings which interfere with the progress of the election, and the second which accelerate the completion of the election and acts in furtherance of an election. A reading of Mohinder Singh Gill's case points out that there may be a few controversies which may not attract the wrath of Article 329, B, to wit, a power vested in the functionary like the Election Commission, etc. But if I may take you a few lines down to Roman numeral 2, a dispute raised may not amount to calling in question an election if it subserves the progress of the election and facilitates the completion of the election.
Yes. Go ahead, I'm following you.
So the court is examining its previous decisions, my lady, and is making a distinction between the types of challenges that may arise from time to time. And if I can, on the following pages, going through 7, 8, 9, and 10, the court is examining those previous authorities, and it concludes on page 10 as follows. This is from the middle of the page with the paragraph beginning the Founding Fathers.
Yes.
As the Founding Fathers of the Constitution have consciously employed use of the words, no election shall be called in question in the body of section 329B, and these words provide the determinative test for attracting applicability of Article 329B. If the petition presented to the court calls in question an election, the bar of Article 329B is attracted, else it is not. For convenience sake, we would now generally sum up our conclusions by partly restating what the two constitutional benches have already said, and then adding by clarifying what follows therefrom in view of the analysis made by us here and above. And then they say 1, and if I can direct your attention to 2, any decision sought and rendered will not amount to calling in question an election if it subserves the progress of the election and facilitates the completion of the election. Anything done towards completing or in furtherance of the election proceedings cannot be described as questioning the election. And we are saying, Milady, essentially, Milady, I'm inviting you to read the entire decision, of course, but I'm drawing to your attention the important paragraphs. We are saying that our case falls within that category. We are not questioning the election because we haven't gotten to that stage of knowing what the result is yet. We are in the middle of the process, and we have discovered that the election official is not following the process that is provided for under the Act. We're asking the court to intervene to assist the election officials in carrying out the count in accordance with the law that guides them. My lady, there are two decisions of the High Court of Guyana, and in particular of Chief Justice Bernard, as she then was, dealing with the ouster of the jurisdictional court in election matters that I would wish to bring to your attention. The first is in the matter of an application by Audrey Norton for writs of certiorari and prohibition. And you will see that in this particular case, the court felt that because there was a challenge to decisions made by the chairman of the Elections Commission, which were ousted by a particular provision of the Constitution, that relief was not granted. But what I would like to draw your attention to, lady, is what Chief Justice Bernard said at pages 386 to 387 of that decision. And at the bottom of the page she says, before formally pronouncing my ruling in this case, there are some observations which I feel compelled to make.
Just a minute, page
386 from the bottom of the page, please, ma'am.
Yes, I know.
Have it? Yes, but at the bottom page. First, I must stress that contrary to a popular misconception of this case, this case is not concerned with the validity of the national elections held on 15 December. I have not been required to pronounce on this, and I wish to stress this again. The question of the validity of the election needs to be decided on at the hearing of an election petition or petitions filed by the political parties who challenge the results. The petitions will give these parties a full opportunity to ventilate in a court all of the evidence which is in their possession to review the validity of the polls. This action was mainly concerned with the conduct of the chairman of the Elections Commission in declaring prematurely, this is Janet Jagan, President, without the consent of the other members, and before the final results were obtained. Certain preliminary objections were raised concerning inter alia certain articles of the Constitution. It is on these objections I have ruled. At the risk of being repetitive, I state again that the validity of the elections, if so desired, can be challenged by the filing of an election petition, which will be heard by the court. So you see, my lady, that she was treating the question whether the election commission made a decision without the consent of other members and before the final results were obtained. That is a question that is not a question concerning the validity of the election, but again is a question that concerns the process that is being followed. And therefore it is one that would fall properly within the ordinary supervisory jurisdiction of the court. More to the point, my lady, is the later decision of Chief Justice Bernard, as she then was, in the case of Joseph Hamilton against the Guyana Election Commission, Mr. Bharat Jagdeo and the Attorney General, a case that my learned friends of this side are very familiar because they will counsel in the matter. And you will see from the first page, my lady, that an order was being sought, an order or rule nisi of prohibition directed to Chairman of the Elections Commission, Mr. Joseph Singh, a public officer, from declaring Mr. Jagdeo as President of the State of Guyana on the ground that any declaration would be unlawful, etc. And there are other reliefs sought. But if you look at page 3 of that printout, my lady, you will see what the nature of the complaint or the question that was being asked in that case. And it is very similar to the question that was being raised in this case, if not identical. It says, the applicant, a member of the Central Executive of the People's National Congress, reformer, in summary alleges that the returning officers appointed by the Guyana Elections Commission did not publicly declare the votes recorded in the respective districts with respect to each list of candidates in accordance with Section 84 of the Act, and did not ascertain the total votes cast in favor of each list in their districts by adding up the votes recorded in accordance with statements of poll in the presence of candidates of the People's National Congress and counting agents. Further, the Chief Elections Officer used a computer system which was unreliable, something like a spreadsheet. Also, the Election Commission has been using tally sheets instead of statements of polls to determine the votes cast in favor of each list in breach of the Representation of the People Act. So that is a very similar question that was raised in that case by the then opposition. And these were proceedings that were brought by way of judicial review, not the election petition. And you'll see what Chief Justice Bernard had to say about that at pages 16 onwards, my lady, and I ask you to forgive me if I read liberally from these paragraphs because they're important. At page 16, she says, as I said in relation to the chairman of the election, at the bottom of the page,
Yes.
in relation to the chairman of the election commissions in Norton in deciding whether certiorari lies against the chief elections officer this time, I can do no better than adopt Lord Parker's formula. The election commission is a statutory body of persons of a public, as opposed to a purely private or domestic character, whose function is to determine supervisorily and administratively matters affecting the citizens of Guyana, with a duty to act in a manner to ensure impartiality and fairness, which in effect means to act judicially. And then if I can ask you to drop down to the last paragraph beginning, I now turn to the question of alternative remedies. The National Assembly Validity of Elections Act was enacted in 1964, and she indicates what it's intituled, and then she says, therefore primarily concerned with questions relating to the validity of elections. A method is provided in Section 3 of the Act for questioning the validity of the elections in a court of law, and then she reads those sections. And these paragraphs on page 18 are important later. It is lucidly clear that the validity of the results of an election can only be challenged by the filing of an election petition. In this regard, both counsel for the applicant have stressed ad nauseam
that he is not seeking to challenge the results of the election, and I trust this has been made quite clear to the public at large. The applicant seeks to have the Chief Elections Officer and Election Commissions perform the statutory duties imposed on them. Counsel for the respondents sought to convince me that this is an indirect challenge to the results of the election and is an election petition in disguise. They claim that if unlawful acts or omissions occurred in the conduct of the elections, then the only form of redress is by election petition, which provides an alternative remedy. I agree that if the results of the elections were tainted by disenfranchisement of voters or multiple voting, these issues can only be ventilated at the hearing of the election petition. I have no power in these proceedings to deal with such unlawful acts or omissions. However, the applicant's complaint is not about the validity of the results of elections. He seeks compliance by the Chief Elections Officer with his statutory duties. The affidavits filed in support of the applicant's motion, particularly the last one filed on 29th March 2001, have cast doubt on the efficiency of the work of the Elections Commission. It's hardly a secret that there have been significant irregularities, presumed or real, in the election process. It's also commendable that efforts have been made to reduce doubts that surround the process. However, serious doubts still remain, and the populace demands answers. It's almost deja vu. As mentioned earlier in the judgment, the role of the Elections Commission and its staff is to take such action that appears necessary to ensure impartiality, fairness, and compliance with the provisions of the Constitution and any other acts of Parliament. Milady, in the present volatile situation which pervades our country, and Milady, I'm reading from the judgment, I'm not commenting, no effort must be spared to assure everyone that the process was fair and impartial. Lingering doubts that hang like the sword of Damocles over the head of the Commission must be removed. Confidence in the electoral process must be restored. This is absolutely essential if we as a nation are to move forward and strive to heal the wounds that divide us. Let fairness pervade all of our actions at all times. And for all these reasons, I order the Chief Elections Officer and the Elections Commission to comply without delay with Section 84(1) of the Representation of People Act, which, milady, is almost precisely the order that the applicants are seeking in these proceedings. Comply with Section 84(1) of the Representation of the People Act as the first order of the day. Of course, if we get to 84(2), then it's complied with 84(2). That is the precise order that we seek in this case, which is the precise order that Chief Justice Bernard had made in that case, pointing out that we are not talking about the validity of the election. We haven't gotten there yet. We want to ensure that the election officials perform their duty. And it is no comfort to anyone to say, as my learned friend has suggested, well, let us suffer an election official who, on the evidence, is apparently deliberately flouting Section 84(1). Let us suffer that. Let us have an election declared. Let us have a government put into power which, on the evidence, should not be there, because you can then launch an election petition and let that go through the normal processes of the court to reverse it at some point in time down the future. The wisdom of Chief Justice Bernard in this case is to say that in order that the public can have confidence in the entire process, can have confidence in whatever result is declared, let us ensure that there is transparency. Let us ensure that the public officials are performing their duties in accordance with the Act, that the public go home knowing that whatever the result may be, they certainly cannot question whether the Act to its letter has been followed. And I haven't heard my learned friend suggest that we are somehow mistaken as to whether the process has or has not been followed. This is a purely technical, as he's entitled to take, purely technical jurisdictional point. But my lady, the Act must be looked at, the Act must be interpreted, and it must be interpreted
in accordance with the normal presumptions in favor of the court carrying out its constitutional duty of ensuring that public officials comply with the law. Chief Justice Bernard has pointed the way forward as far as this case is concerned. I would therefore ask you to respectfully reject my learned friend's point in limine and allow the proceedings to go on.
Yes, thank you.
Assist you any further, my lady.
Thank you.
Much obliged to you.
Somebody doesn't know where they are. Could you kindly admonish that person, Marshal? Yes, Mr. Wilson.
Now, first, Justice Bernard in Hamilton's case, one of the issues there, the court has to decide an argument whether Section 84 of the Representation of People Act was mandatory or directory. When it says as soon as practicable after the receipt of all the ballot boxes and the envelopes and packages delivered to him in person, Section 82, the returning officer shall do certain things. This is what Justice Bernard had to say.
Which page, where are you reading?
I'm reading from a cyprostyle. And this deals with, I'm dealing with page 15.
Or just a minute, just a minute. I don't know if that's the one I have. How does it begin?
In this regard, she says Section 86 is not mandatory but directory.
Yes, I see that.
In relation
So that's on page
to
15.
Section 84.1, the opening words are significant. As soon as practicable. There is no strict time limit imposed, but it imposes a duty to act with dispatch. Overall, I think, though not mandatory, the provision imposes a duty on the returning officer. And although in my view, non-performance of this public duty may not render acts done in the performance of the duty null and void. So, it is a duty which is binding and should be carried out. Now, what Justice Bernard was dealing here with, she was not dealing with an issue where an election was called into question. Counsel for Hamilton has always been saying this is not a challenge to the election. This case, the summation of the allegations by the applicant and the affidavits go towards an unlawful act that was conducted in the course of the election. My learned friend has said to you in relation to Section 84, it is the returning officer for Region 4 who declares that result when he has gone through all the statements of poll. And then he forwards that result to the chief election officer who will put all the results in all 10 regions and declare it. So the chief election officer did not have to declare the result for Region 4. It is the returning officer who so declared.
Please repeat that, sorry.
The chief election officer doesn't have to declare at the counting of the statement of polls. If we look to 84, as soon as practicable of the receipt of all ballot boxes and the envelopes and packets delivered to him in pursuance of Section 8310, the returning officer shall, in the presence of such of the person entitled under Section 86 to be present as attend, ascertain the total votes cast in favor of each list in the district by adding up the votes recorded in favor of the list in accordance with the statement of poll, and thereupon public declare the votes recorded for each of the list of candidates. And that is what he did on the 5th. So my learned friend refer you to Section 96. The chief election officer shall, after calculating the total number of valid votes of electors which have been cast for each list of candidates on the basis of the vote counted and the information furnished by return officers under Section 8411, ascertain the results of the election in accordance with. So it is after the results has been given to him for all 10 regions. He, having ascertained those results, then he will answer this commission.
My understanding of what Mr. Mendes is saying is the result that is declared by the returning officer of Region 4 is not a national declaration, and therefore it is only when you are faced with a national declaration of results then the issue of the election petition kicks in. But until such time, we haven't reached that status yet. That's my understanding of his argument.
No, well, my understanding, I may beg to differ in the sense that after that election, that results have been declared, a counting agent for the region may ask for a recount by 12 o'clock the next day.
Yeah.
And if he does not, that is final.
Right.
And that is what goes to the chief election officer. And so he can prepare his statements to hand to the election commission, where the chairperson will make the declaration.
Anyway, I'm still trying to understand how you're distinguishing Hamilton.
How I'm distinguishing Hamilton? I'm distinguishing Hamilton for the simple reason, or on these grounds. Hamilton, the Chief Justice, was dealing with Hamilton, which was not challenging the validity of the conduct of the election.
Just make sure.
This was a prerogative writ that was filed after the elections, after the declaration was made. This was not...
No, it couldn't be, because if Justice Bernard's order was at the end that the CEO was to comply with Section 84, then it could not have been after. If you had to comply,
that goes after.
Comply without delay with section 84.1. Anyway, I'll read the decision, but that's
Yes.
the order that was made, so.
But as we are saying,
And
If they-
what Mr. Mendes is
she
saying, that's
says
exactly what they're
comply.
asking for.
with the great respect, the Chief Justice cannot introduce a two-part stage.
So you're saying Hamilton is wrong?
Wrongly decided,
Okay.
if it tends to introduce a two-part stage.
All right, just let me make that note. Hold on, just a minute. Okay, thank you. Yes, Mr.
Yes. So what we are saying, if she, by that writ came after declaration, if by that the Chief Justice was saying, if that intermediate writ was filed during the election process, where the substance of the conduct of the returning officer points to some act which shows some act or omission which shows that that election for that particular district was not conducted in accordance with the election law, that decision is completely wrong.
Okay. I will bear that in mind.
And you are not bound by that. A judge of coordinate jurisdiction. My learned friend referred to Election Commission of India and Ashok Kumar. This relates to an election in the Indian state of Kerala. Now, the election officer has given a directive that the votes cast in that state should not be counted by booth. What you must do is to collect all the votes, all the boxes from the various booths and mix them together. And having intermixed them, then a count should be taken.
Yes.
Ashoka says this could not be right because if you mix them together,
That's what the court held.
no,
That was the
Ashoka,
that was
Yes.
the contention.
yes, that was the contention.
Okay. Yes.
And he brought a writ petition seeking prerogative writs pursuant to Article 226 of the Constitution. He did not use Article 329. Because he said this can't be right, because if you mix them up and there is confusion at these various polling booths, how will we be able to ascertain which booth there was subterfuge? He went to court He also sought injunction proceedings.
Yes.
To set aside the direction given by the chief election officer in relation to how these votes should be counted. The court did grant the order, and he appealed.
The court did not grant the order.
Yes, the court did not grant the order, sorry. The issue arising for decision in these appeals is the jurisdiction of the High Court to entertain petitions under Article 226 of the Constitution of India and to issue interim direction after commencement of the electoral process. So can interim relief or directions be given after the commencement of the election process? They cited Mohinder Singh case.
I know, but I'm trying to find out what about this case you're distinguishing?
No, I'm coming to that. The court said, see paragraph 29 in Mohinder Singh Gill's case. The Constitution bench noticed two types of decision and two types of challenges. The first relating to proceedings which interfere with the progress of the election, and the second which accelerate the completion of the election and acts in furtherance of an election. My submission is that this proceeding brought by the applicant interfere with the progress of the election.
Yeah.
The court also said a dispute raised may not amount to calling in question an election if it subserves the progress of the election and facilitate the completion. We are saying this doesn't facilitate, this delays the progress.
Yes.
So, as it relates now, but there is a case. So this was Ashoka was decided in date of judgment 30th of August 2008, and we have Dr. S. Palpandi versus the Chief Election Officer of Tamil Nadu.
There's a different case you didn't cite
Yes.
earlier.
No, I'm now using this to show that this case,
That Kumar.
yes, came 90 years after Ashok's case.
I'm sorry, I have to interrupt you. The defense, first of all, has not provided me with any of his affidavits so that he would assist the court. I provided him with mine. He obviously knows of the Ashok case. He told me that he knows of it. And although I handed it to him, he didn't have the courtesy to give me that decision so that I would be in a position to assist him by responding. It is unfair for me, my friend, not to be relying on additional authority, particularly when he knew that I was going to be relying on the Ashok case because I gave it to him. What he ought to have done is that I would have say, I am going to rely on this case witnesses. Now what am I going to do?
Noted, Mr. Mendel. Yes, Mr. So you're saying this new case that you want to cite is is which year?
This came 19 years
Which one came 19 years?
after Dr. S. Palpandi.
Listen. Kumar's case is 2000. Ashok
2000.
Kumar.
And this
And
came
this one that you're citing is dated when?
2019, repetition of 2019.
Do you and Mr. Hunt have a copy to give Mr. Mendez? Do you have a copy?
Yes, I
certainly
certainly
Do you have a copy for the court? Do you have one for the court?
We will get one for the court. You have one.
So let me honest. Could you spell the word? What is the name of the case again?
Dr. S-P-A-L-P-A-N.
Or don't worry, Palpandi. I got it. Yes, and this is a 2019 case.
Now, the Supreme Court reviewed more in the same case as well as Punusami's case, inasmuch as the court in Ashok's case made that distinction. It re-emphasizes the issue that was raised and the apex court has decided. What it says at page 8, the question now raises whether the law of election in the country of India contemplates there should be two attacks on matters connected with election proceedings. One while they are going on by invoking the extraordinary jurisdiction of the court under Article 226 of the Constitution, and another after they have been completed by means of an election petition. In my opinion, to affirm such a position would be contrary to the scheme of Part 15 of the Constitution and the Representation of People Act, which, as I shall point out later, seems to be that any matter which has the effect of vitiating an election should be brought up only at the appropriate stage in an appropriate manner before a special tribunal, and should not be brought up at any intermediate stage before any court. It seems to me that under the election law, the only significance with the rejection of the nomination paper consists in the fact that it can be used as a ground to call the election in question. So the conduct of the election officer of the Region 4 returning officer can only be used to call the election in question. Article 329B was apparently enacted to prescribe the manner in which and the stage at which this ground and other grounds may be raised under the law to call the election in question could be urged. I think it follows necessary by implication from the language of this provision that those grounds cannot be urged in any other manner and at any other stage and before any other court. If the grounds on which an election can be called in question could be raised at an earlier stage and errors, if are rectified, there will be no meaning in enacting the provision like Article 329B and in setting up a special tribunal. Any other meaning ascribed to the words in the article would lead to anomalies which the Constitution could not have contemplated. One of them being that conflicting views may be expressed by the court at the pre-polling stage and by the election tribunal, which is to be an independent body at the stage when the matter is brought up before it. And they went on and re-emphasized Punaswamy as well as Govindra Singh. It is now well and well recognized that where a right or a liability is created by a statute, which gives a special remedy for enforcing it, the remedy provided by the statute only must be availed of. This rule was stated with great clarity by Wells J. in Wolverton New Waterworks Company and Oxford. Just now, Your Honor.
Mr. Boston, since this case seems to be supporting what you had said earlier, I would have thought that you would have cited it.
You thought I would have cited
I would have cited it earlier rather than in reply, because it's not, from what you've read, it does not establish anything new. It is confirming that which you have posited.
No, but I plan, as I've done, to use it in response to a Ashoka case.
No, you shouldn't have waited to respond. You should have cited it from the beginning. Thank you very much.
Could I ask this as best as I can?
Yes.
First of all, lady, I cited the, you will notice, of course, that the learned friend has not referred to any passage that deals with the Ashok case. I'll tell this one. And he says that Ashok was never mentioned.
Well, it was not mentioned, he said.
It was not mentioned, he has just indicated to me.
Oh, I thought you were saying it was mentioned. I
This
was
is what
listening
I
to
thought
find
as
out
well.
when, but anyway.
So that to the extent that my learned friend is suggesting in this case casts doubt on the distinction that the Ashok case made, he is now admitting that it does not. But in any event, my lady, I cited the Ashok case simply for those distinctions that the court was making. But in reading this decision, you will appreciate that the courts in India are applying a specific provision in their constitution, that is Article 329B, which is in the form of a general ouster of the court's jurisdiction. And of course, you have to look at the wording. The provision that constitutes the ouster, which this court must interpret, is Section 3 of the Representation of the People Act, which does not use words that are similar at all to Article 329B of the Indian Constitution, and Rule 3 of the rules passed by the Parliament, which, my lady, I have already analyzed. I'm not going to go through again. But that rule specifies the specific questions that must be brought by an election petition. And the question that is raised in this case does not fall within those questions. So, my lady, in reading this case, I just ask you to bear in mind that the court was interpreting an entirely different provision. But I nevertheless rely on the approach of the court in Ashok in making the point that there's a distinction between challenging an election, the validity of an election, and intervening in order to progress the election, and of course progress it not otherwise than in accordance with law. That is what it's all about. You're progressing it in accordance with the law. That is what we are seeking to have done in this case. Much obliged.
Thank you very much. All right.
So one point, correction, a correction. My learned friend has said to you that Section 84.1, or under 84.1, the returning officer declares a result. That is not what the section says. It does not declare a result. The words are, thereupon publicly declares the votes recorded for each list of candidates. The votes recorded are, of course, the votes recorded on the statements of poll. That is what it's referring to. The words result, declaring a result, do not appear in the section. I'm just making that point. And similarly, if you look at 84.11, which is the end of the process, again, it does not say that he declares a result. It simply says that he provides to the chief election officer the total number of valid votes cast. Much obliged.
All right, thank you very much. I know I said this morning that we would most likely work tomorrow and Monday. I think Monday is going to have to be a day off if we get past this preliminary point. But I'll rule on this at 1:30 tomorrow afternoon. I know it's a bit tough, but I prefer to have us know the way forward one way or another, and then we can take the break on Monday if it is that it goes forward. Okay?
Sorry about that.
Sorry?
The acoustics are not so good. I didn't hear what you.
Yes, what I was saying is that this morning I had indicated that.
Yeah, I'm sorry.
That we would work both tomorrow and Monday, although Monday is a holiday here in Guyana.
Yes.
I'm now amending that. I will rule on this point tomorrow at 1:30.
Much obliged.
Yes, let me call it 1:30. I do hope not to push it to 2 o'clock. Let's say for 1:30. And depending on which way it goes, we will take the break on the Monday and then resume on Tuesday.
Much obliged.
But as it stands right now, I will rule on this preliminary issue tomorrow.
Much obliged.
Yes, I doubt it will be a very lengthy ruling, but given the time frame, but I will do my best. Thank you very much, everyone.
Thank you very much.